So in this section, we're going to talk about how to claim your own equity. And this is meant to be an introduction to the syntax class that we're going to hold. Now, we can get into what is syntax and word power. I think if you'll understand here in just a minute, I'm going to give you some examples of information that you already know. And in fact, I'm going to give you, I hope you're taking notes tonight, because I'm going to give you not 100 but 200% proof that what I'm going to tell you how to do is valid. Then how you apply it will determine whether it works, because it has worked. I will start off with an example that just happened. In fact, in the class, I'll show you the video proof of this. There was a debt collector from a couple of years ago. The law firm communicated with me with a collection. Law firms are typically buy at paper, and then they collect on debt paper, right? Well, they said, well, we are going to collect this. We want to make payment arrangements and blah, 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 blah. Typical debt collector stuff. You have to understand everything they're sending you is an offer to enter into an agreement, but it's not a contract. This is going to be a very important concept to learn in the class. They cannot live in the world of contracts. They can only live in the world of offer and acceptance, and you have to volunteer. Everything in their courts, everything they're doing, whether you think you are or not, you're volunteering for. And every step of the way, they're going to ask you questions. You're going to say yes or no, sir, and move forward. Well, in this case, they sent me a debt collector letter saying we're representing XYZ Bank, and I'll say it was U.S. Bank to keep the story straight, U.S. Bank, and we're here to collect this money. And I gave them one of our you can have access to these debt collector letters, but I've used those before, and in fact I used it years ago on the same matter with another law firm, and it worked fine. They did, after 3 or 4 letters, they finally kind of went away. What I did differently this time, though, is I put together a brief letter, and then I syntaxed the document. Now, what I did when I syntaxed is I broke down words and issues, and I'm going to cover a few of these here in just a minute, but I broke down words that start with D-E and R-E and A followed by 2 consonants and boxes, things like that. Again, we'll cover all this in the class. But those markings and the way I presented it on that document, along with my $1 stamp, thumbprint, a certain way of autographing my name, and a copyright copy claim statement on there, front and back. When I did that, I sent it to them with certified mail, and then before the green card came back, that's the return receipt card, when I sent it to them, I got a FedEx package in the mail. And the FedEx package basically saying, we apologize, we will cease and desist collection. Basically, we have the right to collect in the future, but, we're going to cease and desist. They know what was coming next. I've never seen a debt collector action with a public entity of that nature shut down that quick. So I know it worked. But then recently, something totally out of the blue happened. I was doing some credit work, essentially to clean up some credit. How you can work on your credit rating and clear up your credit reports and whatnot. I actually have an organization who we refer people to. Their link is in the premium member page. They were doing the work for us. They do amazing debt correction work. Well, anyway, they had sent them a letter, not about debt collector matters, but simply we want disclosure of certain things, very basic stuff about credit. Well, apparently that debt has been sold by USAA Bank, another bank, different bank, to the same law firm that I beat up before. Well, the law firm responded to me out of the blue. We didn't even expect this, basically saying, we have ceased and desist collecting on this matter. I mean, I noticed, remember, I haven't sent them a letter, one of my debt collector letters. They sent me a letter ahead of time saying, we are ceasing and desist, we're going to do a cease and desist collecting on this matter. We apologize for any inconvenience. Here are some of the documents you asked for, but these papers no longer belong to us. You have to talk with your bank. So they literally quit before I could do the syntax this time. They don't want anything to do with me because they know what's coming next. It involves USC 1001 and various postal fraud matters that would come up. That's the power of this technology. And you say, well, that's just a debt collector. I assure you, from the examples I've seen, the people I've learned much of this from, I've seen far more examples of that. We've seen court cases and divorce cases and debt collector cases and lawsuits and tickets and tax cases and all kinds of things that this can be used to attack. Yet, we do it in a way where we're not attacking it. We do it in a way where we're asking questions. And we create forensic evidence. Now, this is a service we can also provide for you, by the way. It's available now if you want syntaxing work done. And some people like that because then I'll actually do it for you. You get an example of it, and you'll learn by seeing it actually done. But this class will teach you most of what you need to know to tackle these matters in this upcoming class. And if you're coming in late after the class starts, that's okay too. You can just go back and start watching the videos and look at the examples. This class will probably take 8 to 12 weeks. I don't know exactly because I haven't given the class yet. I don't know how quickly the class is going to absorb the material, but it'll all be recorded and available to our premium members only. So if you're a premium member of UR Law, you're in luck. You get this material included. If you want additional services like syntax work, well, you'll have to look up the details on that. The bottom line is we can take a document and we syntax it a certain way. We mark it all up. It'll have maybe hundreds of marks on it. And these marks are asking questions about words, about language, about style, about spacing, about symbols, about barks codes that are on there. These are all things that affect that piece of paper as a contract and probably void it as a contract because there's no full disclosure and consideration and a meeting of the minds as to what it means. There's no definitions provided of words that we're asking about. And guess what? A contract is not a contract if those kinds of questions exist. And this could be a sentencing agreement, a probation agreement. I think anything that they write in legalese, we can ask questions about. And by asking, all we're asking for is technically called a suit for correct name and language performance when we respond. We're setting them up. They'll know that we've caught them violating a whole bunch of laws just by asking, but without accusing. That's the beauty of this. We don't accuse. We just want them to go away, right, for the most part. A lot of people want to get money because they've been wronged. I get that. But my first objective is to just get the thing to go away. So in this class, you're going to learn how to sue for the correct name and language performance. Are they using a nom de guerre name for you and for them? That is a name with a middle initial. Nobody here was born with just a middle initial, well, typically anyway. But yet they're calling you that. No, they're calling you a nom de guerre. Look it up. It's a term that means a fictional thing, basically. So you'll first catch that, then you'll start asking for language performance. And then you could probably more effectively, and however you're approaching things, I think you should get this in as evidence in your case and start asking questions. Asking. The king asks the questions in his court. He is as king. So you can more effectively deal with court, collections, tax, mortgages, suits, child support issues, government agencies, attorneys. By the way, every attorney has got an issue. If you watch that other video about foreign registration, that just came out. But anyway, all are regularly using language fraud. And all you have to do is highlight it, ask questions, which is essentially a denial of their offer to contract without fighting. You're not saying denied. You're saying, hey, answer these questions and correct them, and then we can proceed. That's actually a conditional acceptance. Puts you in honor, puts you in control. So we ask for correction. And if they don't correct the flaws and they're sending these offers through the mail, well, that's also a postal fraud that they've committed. And they've probably, I've never yet seen them give clear definitions and try to answer this because they're using word art tricks on you, and you just caught them at it by asking the questions. So I'm going to give you some examples here, and I hope that you're paying very close attention. I'm going to give you 200% proof. Now, as I was preparing for this, I opened up just a generic, it's called Barron's Dictionary of Legal Terms. And I just started looking up words that start with D-E and then have a consonant following it, or DI and have a consonant following, or starts with an A followed by two consonants, or R, E, or RI followed by a consonant. Those are trigger words because they can have dual meanings and you'd never know which meaning they're referring to. And I'll give you an example. They actually are called negative words that have a positive meaning, which makes no sense if you think about proper grammar. And again, I'm going to prove it to you right now that you know that this is already being done. In fact, you know obviously, for example, like de-emphasize means not to emphasize. It means no. We use DE as no. And by the way, the rules don't change when you use it in different words. It's the same structure of language. Yet they're using it both ways because they're using multiple dictionaries. Defeat. That means no win, right? To decelerate. That's a negative, right? That's a no. It means to slow down. It's a no accelerate, not accelerate. Okay? To defraud. That's a tricky one. Because they may say you defrauded the government of something. But in factuality, you had to have frauded them, not defrauded them, because it's a negative word. You see what they're doing to you? The meaning has no word. And if you took the word out of the sentence, what does that do to the claim? It changes its meaning because the word's gone. We're going to show you how to do that. Defective. Okay, you know what that means? It's not effective, right? D is in no. Decompose. Okay? It means no. It's a negative. It's not composing. It is decomposing. It's a negative. Decriminalization. It means to not criminalize something, right? But don't they also use it in words like defense? Defense is supposed to be for your protection, right? But in actuality, it's a negative word. It means no protection, no fence. You ever wonder why when you hire an attorney and you just hope that he'll put up a defense, you'll lose 95 to 98% of the time? Did you know that? That's because you started with one simple word that's a losing word. And you think you could learn all this stuff about the law and all this kind of stuff? Good luck. So I'm telling you, folks, they're tricking you with these words. It's starting with the very important word of defense or describe. Why don't you come and describe what's going on? Describe is no scribe. It means not explain. You explain. You do just the opposite of what they ask. No wonder they don't listen to you. Declaration. Declaration. Declaration is they're declaring you insane. But it's no declaration at all. It's a no contract. When we use the word no, it changes the word to a no contract. Think of it that way. And so if the word no contract is written all over an indictment or all over a ticket, what does it ultimately mean? Declaratory judgment. They do that to people all the time. But it's no declaration because you think the word declaration means something, but it's multiple words in one word. And that DE means the same thing. It's a no contract. De facto. People talk about the de facto and the de jure. What if I tell you I don't care what either one of them say because they're both negative? Deductions. My gosh, you took illegal deductions. But those are no deductions, no contract. In other words, these words that are all over these papers are really negative, no-meaning words. They don't have a meaning, and they're certainly not defined for you with a dictionary that's attached. And every paper you're dealing with is the four-corner rule applies. It means whatever's within that document is the limit of what there is. And if they don't give you definitions of these things, and they're using this style of writing that has positive and negative meanings in the same sentence, well, you've just disqualified the document. Does it make sense? Just take a few words out of a document and it's defective. It's no longer a contract. It never was a contract. We can do this with A as well. Like asymmetrical, not symmetrical. Acceleration clause. They do that on mortgages. That's a negative. It's no acceleration. Assumption of liability means no assumption. They want you to assume liability for the charges, but assume itself is a no assumption. Yet, if you let it go, you've agreed to it. So you've got to start learning how to read these words, break them down, ask questions, mark the page up the right way, and then all kinds of things can happen. Because they'll know they've got to answer these questions. They can't put you into a contract. As a matter of fact, we'll talk about in class that you could make an American Disabilities Act claim when they do use this language on you, because they're putting you into a legal situation without giving you an interpreter who can actually interpret the words for you, which is what they call the attorney. But even he can't do this. Believe me, I've tested this on attorneys. They don't know this. So if they can't help you, then who's going to provide you where's the interpreter? You know, we can't proceed until I've got this. Do you see how valuable this might be? Then there's the rules of boxing. That's always a fun one. Learning how to identify everything in a parentheses or in a square box or in a boxing symbol or in quotes in many instances is an omission from the page because it's a contract within itself, the four corners rule. So that's a fun one to identify. Well, you look at property tax statements, just nothing but boxes. A lien, IRS lien, nothing but boxes. There's all kinds of defects with these documents. And if you can just simply not get into the legal arguments and simply stay on the defects in the contract, that's the arena you can win, because all questions are answered. Because they cannot tell you to do something if you don't understand. And if you don't accept the offer by not understanding, you can tie these things up and flip the case right on them. So that's the idea of the training. We'll get into much more details of it soon, but I just want to give you that quick overview. If you're a premium member of urlaw.org, you'll get full access to all this. Keep your membership current. Tell others about it. This will be something that you will study, and then you'll have to study and study and study again. We have hundreds of pages of examples for you to start learning the style of identifying these things and reading this way. And ultimately, we'll take it to the point where you can actually write in what's called now-time language. Some of you might have heard of David Wynn Miller, and I heard that he might have passed recently. I haven't confirmed that. But he was one of the leaders in discovering this way of looking at words. People say, well, he just made up a bunch of stuff. In actuality, he didn't invent it. I've been trained by people that have even a more advanced knowledge of it, and I try to put it in a very practical way of thinking and a very practical way of looking at it, whereas my only critique of him is he's so far advanced, he's on another planet, and then he mixes it in with a bunch of strange stories. I don't need to do that. I just want you to just look at the words, look at the defects, and then once you learn how to do that, then we'll get into the advanced side of how to write in now-time real language. Because, for example, let's see if I come up. Here's another thing that they do to you, for example. Hang on, let's see. I'm trying to find an example. They might tell you, they'll use sentences that have a positive and negative meaning in them. Well, if you know things about grammar, you have to keep the context the same. So it might say, the stated defendant shall plead guilty to an offense he committed. Well, there's a problem with that sentence, and we'll break it down for you. There's no actual noun in the sentence. That's a problem. But also, shall and committed are opposite meaning words in the same sentence. So the sentence itself is a wash. It's literally like if you put white out through it on the page and then looked at the page. What does it say? That's the power you'll have once you get through this course. So I won't spend any more time on this at this time. Just start following along. Watch for notices for those calls. They will be announced on the schedule, most likely on Thursday mornings, Pacific time. More specific details will be on the website. Thanks again.